Hey, what's up, America and YouTube and everybody else? How you guys doing? Thanks for tuning in again today to check out my vids, see what's going on. Today, I'm going to cover a little bit about your rights as a parent in this country. Around the world, they don't have the same types of written regulations that we have that protect us. Okay? Be happy you live in America and not China or North Korea or any of these other, countries that don't really have any kind of freedom. They're completely sheltered and censored off. People always ask me, what's my experience with DHS? How can I, possibly give people, any kind of help or whatever, being that I am who I am in my local community. I'm not I'm not famous for being the nicest guy in the world. Let's leave it at that. But here's my experience with DHS so far. Okay? Tons and tons of paperwork. Never throw any of it away either, because you can always use it again later when they try to harass you again and again and again, because that's what they do. Once they think they're going to get you under their thumb, they just keep pushing and pushing and pushing and pushing until finally you give them something that they can use to take away your kids. For me, I have now made them look ridiculous 6 times. Simply because I choose to medicate myself with cannabis. I'm under the influence of cannabis right now. Does it seem like I'm unfit to, that my mind doesn't work properly, that, all kinds of different stuff. But mainly, your rights as a parent are constitutionally protected. That's right, people. Our forefathers, a long time ago, knew that the state would get out of control and try to step in and, do what the state does. And that's try to control everybody's lives. In my last appeal, I managed to get, and that was on November 18th, 2015. I will try to convert the audio of that hearing into a video so that everybody can... Sammy, enough. I have a talking parrot, so she sometimes gets out of control if I talk a little too loud. And that was, again, November 18th, 2015 was my last hearing. I'm going to try to get that converted to a video so that everybody in the world can listen and watch it. It is on my Facebook. My Facebook is open publicly. I'm the same name on there. I don't, have aliases or, any of this other stuff trying to hide myself. I hide myself behind the Constitution and actual U.S. law and not color of law, which is what the state likes to operate under. What I'm going to cover in this video is the 9 major rulings that I managed to get from the U.S. Supreme Court into evidence in my appeal. And for those that want to try to look up that appeal, which is pretty much impossible because anytime the state loses a case like that, they don't like to keep those records on the books very long for people. But the number is Iowa Courts SVS 15008631. But the first Supreme Court ruling goes all the way back to 1925. It's Pierce v. Society of Sisters, 268 U.S. 510. Fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. Basically, that means parents overrule the state with regards to educating their kids. They can teach them whatever the hell they want, how they want to teach them. Period. If the teachers don't like that, that's just too damn bad. Second one, Moore versus Cleveland, 431 U.S. 494, 1977. Our decisions establish that the Constitution protects the sanctity of the family precisely because the institution of the family is deeply rooted in this nation's history and tradition. It is through the family that we inculcate and pass down many of our most cherished values, moral and cultural. Pretty cut and dry, don't you think? Number 3 is Smith versus Organization of Foster Families. 431 U.S. 816, 1977. The liberty interest in family privacy has its source and its contours are ordinarily to be sought not in state law, but in intrinsic human rights, as they have been understood in this nation's history and tradition, which means they are intrinsic. That means they are inalienable. They're granted because you're a human being, period. It doesn't make a difference. The state does not get to violate your most basic rights as a living entity simply because they say they can. Number 4, Quilloin versus Walcott, 434 U.S. 246, 1978. We have recognized on numerous occasions that the relationship between parent and child is constitutionally protected. We have little doubt that the Due Process Clause would be offended if a state were to, quote, if a state were to attempt to force the breakup of a natural family over the objections of the parents and their children without some showing of unfitness, and for the sole reason that to do so was thought to be in the children's best interest. That is, the thing about children's best interest, that is a venerable phrase at best, mainly used in divorce proceedings to find out which parent the child should live with. It shouldn't even be a criterion for grounds for the state to take your children. They don't have any bearing over a family without a major showing of unfitness. Number 5, Parham vs. Jr. 442 U.S. 584, 1979. The law's concept of the family rests upon a presumption that parents possess what a child lacks in maturity, experience, and capacity for judgment required for making life's difficult decisions. More important, historically, it is recognized that the natural bonds of affection lead parents to act in the best interests of their child. The status notion that governmental power should supersede parental authority in all cases simply because some parents abuse and neglect children is repugnant to American tradition. Simply because the decision of a parent is not agreeable to a child or because it involves risks does not automatically transfer the power to make that decision from the parents to some agency, DHS or CPS, or officer of the state. Number 6, Santosky vs. Kramer, 455 U.S. 745, 1982. The fundamental liberty interest of natural parents in the care, custody, and management of their child does not evaporate simply because they have not been model parents or have lost temporary custody of their child to the state. Even when blood relationships are strained, parents retain a vital interest in preventing the irretrievable destruction of their family life. Until the state proves parental unfitness, the child and his parents share a vital interest in preventing erroneous termination of their natural relationship. Which means, unless the state can prove you molested or severely beat or severely neglected and starved your fucking kids, they can't do shit to you. Number 7, Reno versus Flores, 507 U.S. 292, 1993. The best interests of the child, quote, a venerable phrase familiar from divorce proceedings, is a proper and feasible criterion for making the decision as to which of two parents will be accorded custody, but it is not traditionally the sole criterion, much less the sole constitutional criterion for other, less narrowly channeled judgments involving children, where their interests conflict in varying degrees with the interests of others. Quote, the best interest of the child is not the legal standard that governs parents or guardians' exercise of their custody, so long as certain minimum requirements of child care are met. The interests of the child may be subordinated to interests of other children, or indeed even to the interests of the parents or guardians themselves. Number 8. Washington v. Glucksburg, 521 U.S. 702, 1997. In a long line of cases, we have held that in addition to the specific freedoms protected by the Bill of Rights, the liberties specially protected by the Due Process Clause includes the rights to direct the education and upbringing of one's children. Period. And again, that was as recently as 97 on that one. And then this one, number 9, Troxel v. Granville, 530 U.S. 57, year 2000. The liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court. In light of this extensive precedent, it cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. The problem here is not that the Washington Superior Court intervened, but that when it did so, it gave no special weight at all to Granville's determination of her daughter's best interests. More importantly, it appears that the Superior Court applied exactly the opposite presumption, just like Iowa courts do every day. The Due Process Clause does not permit a state to infringe on the fundamental right of parents to make child-rearing decisions simply because a state judge believes a, quote, better decision could be made. So this whole deal with them saying, oh, it's in the child's best interest that we do this, and it's in the child's best interest if we do that, they have no grounds to even make that claim. Unless they can somehow prove you unfit. Again, people, it goes back to knowing what your rights are. Knowing the Constitution, knowing the Bill of Rights, knowing your most basic principles of being an American. How can you sit out there and be a flag waver and, chant America, America, and have no fucking clue what your rights or responsibilities are as an American citizen? I don't get it. So hopefully, this will open some people's eyes up a little bit, get them to realize, hey, man, the state does not have absolute power over our lives, over our children, over our families, or over us in any way. They don't. And with that, peace and love, everybody. I'm out.